Good day, Internet. Chavez and Valko here with an immigration update. And for once, it is good news. So, a brief summary of what has happened. USCIS has reached a settlement agreement whereby they are going to provide some easing of the work authorization requirements for H-4 and L-2 spouses. Specifically, H-4 spouses will now be eligible for automatic extensions when they file for their EAD or work authorization renewals, and L-2 spouses may be eligible for work authorization automatically without filing a request for work authorization. So, Andrew, why did this lawsuit come about?
Essentially, just because of the long delays of processing from USCIS in terms of, it taking close to a year sometimes for people to get their EAD after they've applied for it.
So, historically, USCIS was pretty good at averaging around 90 days on issuing EAD or the work authorization document, um, which, if you file at the earliest point possible, you could get your renewal in hand before or at right when the current one expires and have really no break in your employment. You could keep working. But under the Trump administration, of course, these started to stretch out to 4 months, 5 months, 6 months, to over a year, right? Meaning you had all of these people who were losing their jobs because once their current work authorization expired, they couldn't continue working, even though they had a renewal pending until the new card was approved. So you had literally hundreds of thousands of people losing their jobs. Now, to go into a little bit more specifics, um, for L2s, right? These are the spouses of L1s, people here as intercompany transfers. Certain L2 non-immigrants will be able to work incident to their non-immigrant status. Incident to non-immigrant status. Andrew, what does that mean?
Essentially, that instead of actually having to apply for the EAD, they would get it just based off of being an L2 spouse.
The important thing is that L2s are essentially eligible the moment they enter the US or they file their change of status and it's approved. But they still had to always apply for the card. And so the idea is, well, why? And this is saying that now certain L2 non-immigrants will just be automatically eligible for work authorization without having to file the actual application at all. Those applications, again, in the best of times, took 90 days and cost over $400. Um, One of the key points here is that they will be able to show their like their visa and their I-94 as a Class C document when filling out an I-9, right, and demonstrating to their employer that they are work authorized. Um, Regarding how this affects H-4 spouses, why are H-4 spouses not automatically getting work authorization like the L-2 spouses?
Because with the H-4, it is not all H-4s that can get employment authorization. So with an L-2 spouse, again, we're not talking about kids, but L-2 spouses don't need anything else versus the H-4, it's generally reserved for people that um, the spouse of someone that already has an approved I-140 or meet certain other criteria. It's not all H-4 spouses that are going to be eligible for employment authorization.
Yeah, so there are certain categories that are eligible of spouses that are eligible for work authorization and others that aren't. H-4s typically are not eligible for work authorization until the Obama administration, right, passed a rule that allowed people who have been waiting, right, that are basically stuck in these backlogs to get work authorization. This applies mostly to Indian and Chinese nationals that get stuck in these really, upwards of 13 to 15-year backlogs, and saying these people specifically, if they've met certain criteria, can apply for work authorization, even though they're in H-4. And this impacts a couple 100,000 people minimum. Now, the weird thing here is that there's a ton of categories of work authorization, right? There's, when you fill out the form, you list your category. It's like a letter and then a number. And USCIS has always indicated that some categories are automatically eligible for an extension when they file a renewal. Basically, meaning that if I file a renewal on time, but my current one expires before the renewal is approved, I can continue working for up to 180 days, 180-day extension. But for whatever reason, up to 40 plus categories of EAD, they had only granted the automatic extension to like 10 or 12 of them. And it did not include L2s or H4s or any of them. So what they're saying here is that if you are an H4, you're not automatically eligible for EAD. But if you have met those requirements and you did get an EAD and you're now filing a renewal, you may be eligible for that 180-day automatic extension. But it is limited because if your underlying H-4 status is expiring, then you may not get the full 180-day automatic extension, right? So it is granted through through your current I-94, of course, the approval or denial of the AD renewal or 180 days, whichever is shortest, right? So it's not an automatic 180 days. Not everyone's going to benefit from this. The name of the case is Shergill v. Mayorkas. We're going to link to the settlement agreement down below if you actually want to read it. Also, we're still waiting on some further guidance from USCIS, specifically around I-9s, and some other stuff related to the, especially to the L2s. Another question, Andrew, what about some of the other statuses that are also eligible for EAD automatically, like the L2? An example would be E1 or E2 spouses.
So currently there hasn't been any action, but the last that I heard, they're planning on taking some action for E1, E2 spouses.
So we're going to link down below to a case that was filed fairly recently. The case is Kang v. Mayorkas. That specifically involves E2. Because when I first saw the settlement, I was like, well, why didn't you just do everybody? Well, they didn't, but a new lawsuit's already out there that's essentially trying to get the same benefit for the E1 and E2 spouses as for the L2 spouses, to basically say, well, no, these people are eligible to file upon entry, so why don't we just make it automatic? Why do we have to make them jump through all these hoops? Pay this fee to get this card that right now is taking over a year. Quick question, Andrew. One of the little details that came out amongst all of this litigation is how long it actually takes USCIS to issue a work authorization card. Do you know how long that is?
I'm going to guess a whopping 12 minutes.
12 minutes. I have to pay over $400 and wait a year for something that takes 12 minutes. What gives? It's not, some people would say, well, it's because there's been this like surge in demand and USCIS doesn't have the resources. That didn't happen, right? The demand has stayed, fairly, again, the whole H-4 thing started under the Obama administration, right? So that had already been in place when the Trump administration came into, at the end of the day, we don't know what the real answer is, other than we suspect that there was a lot of deliberate gumming up of the works done by the Trump administration to purposely delay and deter people from applying for some of these benefits or being eligible to work. Don't exactly know the details, but the E2 one is in the works, right? So to kind of come back and summarize, H-4 spouses may be eligible for an automatic 180-day extension of their work authorization when they file a renewal. L2 spouses may be automatically eligible to work upon receiving their L2 status, meaning they don't even have to apply for the card or pay the fee, that their I-94 and visa will actually serve for purposes of completing an I-9 and demonstrating work authorization. Again, we're linking to the two cases down below, but this is big news. This is big news, right? at a time in the United States where employers are desperate to find people, right? We see all the news reports, and we see all the hiring signs, and heard about all the staffing issues. Well, here's upwards of several hundred thousand, upwards of 1 million people that have been essentially sidelined, right? That are here willing to work, many of whom who had jobs, but are just stuck at home because of bureaucracy and red tape. And now that red tape is about to be cut through. But this is like a good update. Hopefully, we'll get a quick resolution also for the E2s. Also, we hope that USCIS will come out with some further guidance fairly quickly here, so that we can make sure that everyone is doing things correctly in terms of filling out I-9s and not getting into trouble. One thing, I just want to reiterate for your H-4s, remember, you may not be eligible for the full 180 days based on when your underlying status expires. Remember that, right? So you may not be eligible at all if your EAD is expiring on the same day as your status. And so you're concurrently filing an extension of status and a renewal of your EAD. You may not be eligible for 180-day extension at all. So be careful there. It is good news, but it may not be 100% good news for everybody. Andrew, any final comments on this update?
Really excited for the people that will finally be able to return to the jobs they had to leave because of these delays.
And as always, these type of large lawsuits against USCIS, right? They're a collective effort. So we just want to say congratulations to all of the attorneys involved, right? All of these things involve multiple attorneys, multiple law firms working together in order to get this done. It's a big load that needs to be lifted, and it takes a collective action. And we just want to congratulate all of those involved, for taking USCIS to task and getting a great result. But stay tuned as things happen. We'll be back with further updates. If you have any questions, right, you can obviously go to our website, schedule a consultation, email, call us. We're here to answer any of your immigration related questions. But until then, thank you, and we'll talk to you later.